School Boards Association for a short period of time. And that started my education law career in late '98. So prior to that, I worked in HCA, healthcare stuff, which was fun, but education is much more fun. I want to start out giving you my email address. I don't have handouts, but if you'd like a copy of this presentation, and you can send me an email, let me know which presentation you want. I would be more than happy to attach it to the email and send it back to you. My email address is christy.ballard@tn.gov, and Christy is spelled CHRISTY.BALLARD christy.ballard@tn.gov. I was asked to talk about school health law issues. It's not the most exciting topic that I cover, but I think it's very important. There's a lot of misinformation out there and some confusion around certain issues. But I want to start out with my most asked question. In all the years I've been, and I'm a dialogue lawyer a little bit for the department, I talk to parents and school officials, and I'm not anybody's local board attorney. Everybody has to have their own local board attorney, but I talk to board attorneys a lot, and I try to bridge the gap when your attorney is in court or hiking the Appalachian Trail, and I don't give legal advice, and that's why I try to maintain a really good relationship with the board attorneys, because I don't want anybody to ever call me and say, told my client what, and I've had that happen, because I've been misquoted through the years. But I do want to be of any assistance I can be to school officials when they are in trouble. But the most asked question I get by parents and school officials is about headlights, believe it or not. My mother is a retired educator, and I remember her coming home years ago and complaining about going through the drill of having to take a pencil and go through her classroom. She taught 7th and 8th grade math and check each kid's head. And that started though. I'm a teacher. I'm trained to teach math, not to search heads for headlights. And so that's always been kind of a controversial thing. The schools had no-nit policies. And the no-nit policies basically said that if you were found to have nits, we send you home immediately. And you have to get treated, we check your head when you come back, things like that. That was based on a Department of Health regulation. Most of our rules and administrative regulations in public education in Tennessee are promulgated by the State Board of Education, except for rules related to health. So this is the rule. It talks about the Department of Health determines which communicable diseases students can be held out of school for, like TB and things like that. But they also talk about scabies and head lice. Now, I don't hear as much about scabies, but I hear a lot about head lice. The rule is at 1200. And if you ever want to know how to find, it's easy to find state board rules because they have links on the State Board of Education website. But if you want to know any state agency's administrative regulations, you can go to the Secretary of State's website, and they have a drop-down list, and it has everything from, health and nursing boards and all those things like that. But yes, sir.
You mentioned the Department of Education, and you mentioned the Board of Education. Can you explain this?
Sure. Okay, the Department of Education, we're the entity, the commissioner is over the Department of Education appointed by the governor, and we're the state agency that implements the laws. When you look at the duties of the Commissioner of Education in Tennessee, he or she has the duty and obligation to enforce school-related laws and rules. Now, the State Board of Education is an appointed body, and the board promulgates administrative rules, which have the force and effect of law, because they go through a rulemaking process prescribed by state law. And those rules are about curriculum, the standards for obtaining a teacher license and how you keep your license. So a lot of times if you go to a state board meeting, you might hear about a teacher who's having his or her license revoked. That's the entity that does that. Now we have an Office of Teacher Licensing where we process licenses, but it's according to the state board rules and the law. So where the state board is just a board that has, where meetings are open because it falls under the Open Meetings Act, they have a small staff, and they actually office in the same building as we do. They have an executive director and 3 or 4 staff members, including they have their own general counsel. And their general counsel now is Danelle Walker. And she actually, what you might call, prosecutes the teacher license revocation hearings. So if the teacher is having his or her license revoked for maybe doing breach of test security or inappropriate interaction with a student, that teacher gets notice that the state board is going to take action, and they get the opportunity to request a hearing. And that hearing is actually before the Secretary of State's office has administrative law judges. So they get a full proceeding. And then the board acts based on that ALJ's ruling, whether or not to uphold it or to.
So for me, the difference is one's administrative and one handles the claims.
Yes, the state board is more, it's almost like we're the director of schools office, and the state board is like a local board of education. They set rules and policies, and we handle the day-to-day implementation. Okay, back to head lice. Why is this controversial? Well, the CDC issued some new guidance on head lice. And what they basically said, students don't need to be sent home early. It's not a healthcare crisis. They can return to class after treatment has begun. Nits may remain, but crawlers should be gone. It does not spread disease. It's not a personal hygiene issue, although it feels good. And the American Association of Pediatrics and National Association of School Nurses advocate discontinuing no-nit policies. So what the Department of Health did is they basically said in their rule is school systems must follow the CDC guidelines. So when you go to those guidelines, it says, discontinue no-nit policies. That's been a bit controversial because after all these years of sending kids home, school districts and even parents are reluctant to have those policies changed. I think what schools struggle most with is when students get head lice, they may work with the parents on how to treat it, but we all know that if you just use the shampoo, I think it's called Red or something like Red, you can't just use the shampoo, you have to treat the stuffed animals and the coats and the clothes and the blankets and the bedding. If you don't, children continue to get reinfested and they come back to school and bring it to other kids. So a lot of times I talk to schools about making, if you have social workers, if you have school nurses, people that can kind of counsel the families and make sure they understand everything they need to do.
So it says, simply did the right thing. The student brought me a note saying that I had been to the doctor, and the doctor says, I'm treating you, not over, but I'm treating you.
Yeah, I think that's enough. Or in schools even, they accept kids bringing in the packaging of the shampoo saying, the note they're being treated. I know some school districts are still holding on to their no-nit policies. When they call me, I say, well, technically you have to follow, this Department of Health rule, requires it. And it's funny because as an agency, you could argue we enforce state board rules, but maybe not Department of Health rules. So I've tried to let them know that they're out of compliance with the administrative regulation. And I think slowly people learn. Parents have the biggest problem. And because there's some sort of stigma, I think, to having your child have head lice. And there really shouldn't be as much. It has nothing to do with your hygiene practices at home. It's just about kids. And the little kids who have nap time, pre-K classes, they lay on mats and stuff. And I think that's part of the reason it spreads.
Yeah, Christy, one of the problems we have here at Overton High School, we have 92 countries. And where we're running into problems, real problems, is cultural and religious issues related to cleanliness. And we have gone into several, I'm not an administrator, and this is a teacher, but we have crossed lines here that do not have legal barriers. They have not had precedent yet for how you determine priority. So if they say no knit policy and they send them home to a culture that does not have a daily wash, there are some religions that do not like to have regular washings because it's against their religious beliefs. What is your recommendation?
I think the regulations say, again, treatment, and as long as there are no live nets, I think you have to let them back in. I get calls, I'll be honest, I get calls that are good answers to, and one of them is not just a head lice, it's hygiene. If we have a kid that's such, and occasionally you'll have students, they don't wash their clothes regularly or bathe regularly, and they smell so badly. And I've had school districts that, have washing machines in the schools, and maybe the locker rooms, and they washed the children's clothes, and they did what they could. But you can't just keep keeping a kid out of school. And if you've got children with IEPs, it's even more important. You can't just, I mean, you have to provide faith to those children. That's another issue. When I was doing the special ed work, you might have a school district that was keeping a special ed kid home for weeks because they weren't getting proper lice treatment. And that's where I said the best thing to do is work with the family if you can. And a lot of times you can counsel them and help them. There aren't easy answers to all these questions. And try to do what's best and what's prioritize what's best for the child. This little girl probably, I mean, she was just mortified. I felt sorry for her because I can imagine being 13 and having your mother tell a bunch of strangers that. And she said that they won't let us come back till there's no nets. And I kind of stopped and I said, well, actually, that's not what the Department of Health regulations say now. And I went, where's my friend? I said, can you just be off the clock for 5 minutes? Why did you have to give me that? And she said, really? Why don't they call the school? Maybe I can get her back in tomorrow. I don't know. I'm sure it was Metro. But it's controversial. When I was a kid, I remember, I was young enough, I vaguely remember sitting on the little pediatrician's table with my younger sister in the little gowns. I'm from rural West Tennessee, so we'd have to go to Jackson was the nearest place. And I just remember my mom being horrified. I had these itchy spots on my skin and so did my sister. And apparently we had scabies and we got it in school and Mom said, don't tell anybody. Because there's the stigma, like, you know, but it was just something we're calling other children at school. That's the most popular question. That is a tough one. I think you have to be sensitive to the issues you have to do what you can, but trying to keep the kids in school is best. All right, the main statute when you're talking about student health issues is this 49.5.415. It's assistance in self-administration of medications, and it requires guidelines to be developed. And if you've never looked at them, you can go to our website. We have a page that has these guidelines, or you can email me if you can't find them. We're working on our website, but right now you have to be Indiana Jones to find a whole lot on it. So let me know if you're looking. But the guidelines were developed between it's a cooperative effort between the Department of Education and the Department of Health and approved by the Board of Nursing, and that's required by that statute. And it talks about healthcare procedures in general and over-the-counter medications and prescription medications, but most healthcare procedures have to be performed by a licensed healthcare professional, and that's what school officials need to remember. There are some exceptions, and they're in this law, but there are very few exceptions. And the exceptions are glucagon injections for children who have diabetes. And you know, those glucagon injections, it's not like the regular insulin shots, they're pre-mixed. I think because of that, it seems deemed a little bit safer. And I have under no duress, because a lot of the language in the statute talks about a volunteer working for the school district can administer a glucagon injection. It says they have to volunteer under no duress. We know sometimes that teachers get volunteered for things, and so the statute's trying to make it clear that no person can be forced to do this. And I have heard people laugh and say, you know, it's always if you're a non-tenured teacher, especially, you get volunteered. The law's very clear. So basically, a volunteer can administer glucagon, can work with children and take care of children with diabetes, excluding insulin. You cannot have a non-healthcare professional administer insulin.
You need to find healthcare professional, because that is one of our concerns. We have, I'm a paramedic, we have others who are licensed medical first responders, and they have, under the Good Samaritan laws, they have the right to administer it in an emergency situation.
I think it needs to be a school nurse. I think it needs to be a nurse.
Well, if we have a school nurse there only 3 days a week, and this happens on one of those days that doesn't, what is your solution?
Yeah, I mean, I think that you have to call 911, and you have to have a child who has a healthcare plan or a 504 plan needs.
So you've got a student who has 3 to 5 minutes, who's going into an insulin shock, and you say call 911.
Well, it sounds like if you have a child who is at great risk, you need to have somebody available who's licensed to do that. And that's really what the federal law is going children in your system who have to have access to healthcare professionals, you have to provide that.
Reality versus theory. Reality says we have a school nurse sometimes 3 days a week and sometimes half a day. We have 5 or 6 others of us who have different degrees. Some of them are registered nurses, but we no longer have an active license. We have paramedics. We have others. So how do you define?
I don't know about a paramedic. I'd have to look into that and whether or not that person, but I do think that if you have someone who has is certified and licensed, I don't know about a paramedic's license. I don't know what that is exactly. I don't know if it's a
Means that we are allowed to provide injections and treatment on site for any first response.
Why don't you email me that question and I'll look into that? Because I'm not sure, because I know with nursing, it's okay.
I call it health science teacher every now and then.
And
She'll come right up with
they're properly,
Yeah, she's an RN.
okay, yeah.
But the question that we've had to limit is active license. They could be an RN, but they may not be licensed because they may have been a teacher for 10 years, but they have an RN experience. They have an RN degree, registered nurse degree.
What I tell, and also, if you have a teacher who's an RN, and I speak to groups of teachers sometimes, and they say they're put in very uncomfortable situations at times because they're asked to come in and perform medical procedures or leave their classroom. If that is going to be asked of a teacher, then it needs to be clearly, if I'm a teacher, I'm going to want that to be specified in writing somewhere. That is part of the scope of my duties.
If you do that, then you lose the Good Samaritan protection. As soon as you become an expectation, you lose all of your protection. The only way this works is, as you say, it's a volunteer on spontaneous response. If it's designated that that's part of your job description, you run the liability.
Yes, but I'm also worried about the liability of a teacher leaving a classroom even in an emergency situation, and there's a balance. And teachers actually do this a whole lot, and then students get, have accidents and injuries, so I hear that a whole lot, and teachers feel very uncomfortable. And also, there's liability if you're not acting within the scope of your duty.
Right, scope of practice is everything. So, I mean, how do you say no? Or when you say no, or how do you say yes?
I think that I never want a child to die for not getting an injection. But I do think that it sounds like if you have some very medically fragile kids, you need to do all you can to have more people certified.
And that one incident is usually not.
Because you have kids who need insulin injections daily. You can't say we don't have anybody available to do that. You have to provide it for those circumstances. And I think you need to have some emergency procedures.
That child.
That's federal law. That's the Department of Justice. That's people coming in and taking federal law.
I appreciate that, and you're in the Department of Education, and I'm saying that the reality is that's not possible.
It's
That
not
is
possible if a child requires a daily
Yeah.
insulin injection that you don't provide that.
I'm saying that if you went to most of the schools in most of the districts, in my experience as a paramedic, 95% of the teachers would not be able to recognize signs and symptoms of diabetes.
No, I'm talking about regular children who are.
Even if they have known diabetes, that's what I'm saying, is that we have a registered nurse who is the senior licensed medical provider.
So she travels and makes sure
She
kids get
handles
their
3 or
regular
4
injections.
schools, and she's there on a limited period of time. If somebody has a diabetic reaction,
What school district are you?
Metro Nashville Public Schools. And I'm saying that this has come up in faculty meetings, this has come up in parent discussions. What do we do if, here's the IEP, there's nobody here, what do we do? And it's not like we can then put something in place.
Yeah, so you're talking about an emergency situation only. You have people who are there to do the regular.
I'm saying, as a medical provider, first responder, I come on the scene, somebody is moving toward
Yeah.
a diabetic child. I can treat that because that is considered an emergency situation. But if you have somebody who is at the school whose blood sugar shoots up, they haven't yet gone into coma, and I could not treat that student unless I have parent permission. But also, if we can't get the parent, what are the provisions?
Well, I'll look into it. Because you have a license, it might be acceptable. And, if you really have had this issue for a long time, Metro has a whole team of lawyers, so I suggest you should contact Mary Johnston's office.
Christy, we brought this up. I'm saying that every faculty, this is not just my school. This is the district is saying, what about these IEPs? What about
Send me
these
an
specific?
email and I'll call Metro Legal for you. I don't know, Mary Johnston's supposed to be retiring. I don't know who's taking her place.
The school about school properties. The principals are the administrators that determine what they have in their building.
Yeah, but if you're asking a legal question, Metro Legal needs to weigh in. Okay, anti-seizure meds. Oh, cartridge injectors for anaphylaxis. EpiPens, obviously anybody can use an EpiPen for a kid who's in anaphylactic shock. There's actually the only new piece of legislation that passed during the 2013 legislative session was Public Chapter 298. It's the only one that I found was really health related, and it's about EpiPens. It just basically, it is the intent of the General Assembly at schools, both public and non-public, so it specifically applies to private schools. Be prepared to treat allergic reactions in the event a student's personal epinephrine auto-injector is not available or the student's having a reaction for the first time. So what this basically allows is that physicians can write prescriptions to an LEA so that they can stock extra EpiPens. So if the kid, has an issue with an allergic reaction to peanuts or bee sting or whatever, and they don't have access to their EpiPen, then the school can keep them in stock. And so that's a good thing. It passed during the last legislative session. But probably the most controversial is the provision that was added a few years ago to allow volunteers who are trained to administer anti-seizure meds, diazepam gel. It is administered rectally. So you can imagine the debates in the education committee meetings, because a whole lot of teachers, I think TA was very against teachers feeling like they had to be volunteered to do this. And then there were some healthcare professionals that said, this is not as easy to administer and know when to administer. I think that the main thing I heard someone from the Department of Health medical doctor said that if you are a parent of a child who has seizures, you know your child, you've seen seizures before, you can recognize the signs of your child. It requires volunteers to have very specific training that was approved by the Department of Health and the Department of Education. And to be honest, it got a lot of attention in the legislative committees, and it was very controversial. But once it passed, I haven't heard any complaints. I mean, it seems to be working okay. Have you had issues with diazepam gel in your school?
The connective conference, Christy, is not the diazepam. It is the underlying disease that causes seizures. And sadly, the teacher in the classroom is not privy to that part of the student's health record. And so they could be having a seizure.
Why not?
Well, it's the right policy. We've had this discussion.
That's not true.
If I go down and say, the IEP comes back and says these are medical issues, and that this student is likely to have seizures, it doesn't give me the underlying disease that says why they are having those seizures.
Here's the thing, and this is a common misconception, and school officials do this quite often when I used to do special ed work. Teachers would say, well, I don't actually have a copy of the child's IEP. If you are the person providing services to a child, you have the right to have access to any information you need to properly provide those services.
And not all the time is that IEP.
Yeah, it could be a Section 504 or health plan, or an IEP. But I mean, FERPA does not prohibit school officials with an educational reason to know information from getting personally identifiable student information, even if it's healthcare related.
Okay, I really don't want to be the naysayer. I really don't. But considering the size of the classroom, I'm an attorney as well. So here's the deal. We can take a legal position, we can take the actual position, and I'm saying that right now, Metro National Public Schools, even with its body of attorneys, even with all of the lawsuits that are potentially there, is not providing basic health care to the students with IEPs. It is a fundamental flaw that we have students who are not getting IEP response. Now, with that said, once I know the underlying disease of why they're having a seizure, many times it's not necessary to provide any anti-seizure medication. in my experience, it requires a doctor's note, a specific recommendation that under these circumstances, this can be administered, but it is a rare thing. Most people who have some sort of seizure activity have some sort of medication that is oral medication that generally creates a safer, more stable environment, and they still have seizures.
Right. I mean, I was answering the simple question that school officials have the right to have all that information, and there's nothing in the law that prohibits that. Now, if you had Metro, if there are students who aren't getting the services that they require under the law, then maybe parents need to file complaints, and maybe that's what will address it. I mean, if we get calls, we don't do Section 504 complaints with our office because the U.S. Department of Education has the sole jurisdiction for enforcing Section 504, unlike IDEA. Now, we try to mediate those things, and when we get 504 questions, we call the school, we try to work things out and mediate. If the parent is still not satisfied, we tell them that they have the right to go to the U.S. Department of Education's Office for Civil Rights and file a complaint there, and some of them do. Now, for IDEA, under the IDEA, we can take, and we have to have a system for parents to file administrative complaints against school districts when they feel like their child's IEP is not being implemented properly, they haven't been properly identified, the services aren't provided, things like that. So if it's something that's in an IEP that's not being provided and the parent is supposed to get that for the child, then they can file a complaint with our office. I don't know what else to tell you.
Are you speaking about there is no infrastructure, or are you saying that children are not being served?
I think that what we're seeing is the prevailing problem based on budget, and it is a budget issue. Okay, if you have an IEP that allocates certain responsibilities for that student, let's say it requires a teacher, 12 students, let's say then that you have a shared teaching experience, another teacher comes in to take care of that IEP student. Okay, when you don't have that number of teachers present in the building, then the teacher in the classroom becomes responsible for the entire administration of that classroom.
What is your name, son?
I'm Frank Lane.
Okay, what position? Are you a teacher?
I'm a school teacher. I'm a classroom teacher in high school.
Okay. Well, I mean, you should go, like you could call the assistant commissioner for special populations with the department, and they do monitoring, they do focus monitoring their issues.
All that's true, but here's the point.
We're charged with enforcing IDEA.
So our special ed lead teacher, who does a great job of getting us the IEP information, getting us the stuff that we need to have. Everybody has a folder on all the students. And when a problem occurs, if Michael's there, he takes care of it and it's all done. But the problem is when you start looking at allocation of resources to provide the support necessary under the IEP, that's not there. And that's a Metro budget issue.
Okay. Well, I mean, I think that this is kind of taking us way off topic, so I'm going to move on.
I would interject. What you need to say within yourself, what would you like to see happen in your current location? And there are procedures, safeguards already in place to make sure that that happens. And you, as an educator, first of all, if you know for a fact that a child is not being served and you're not doing anything about it, you held out before it as well. Just because it's not your child, then you need to file a complaint. You have the right to file a complaint. So follow the procedure safeguards that are already there. And if you follow those procedure safeguards, I am most assured that the assistant commissioner of special services will hear your complaint and will act on your complaint.
Teachers can file complaints
I know that for a
in
fact.
our office.
And you gotta remember too, it's not best. It's free and appropriate education. It's not best yet. We don't have the funding for this. So if you have, I'm in one school, there are communities that circulate through that whole community. Children are being served. It's not like we're setting up a system where we don't want to serve kids. But every teacher has a health plan that involves particular students, and IEPs for particular students. That's why I asked, is it infrastructure or is it kids not being served?
I think it's both. I think the infrastructure is that there's not enough support to do the things that are required.
And then
Okay.
there's
Well, let's talk about what's required now. Unless one of y'all want to come up here and I'll just sit down. Okay. All right. There's a law on AEDs, a young student athlete died on a court. The bill was filed. There was some confusion. At first, I think the bill would have required school districts to install defibrillators in all the schools. It did not pass that way. It's encouraged. It says LEAs are encouraged to place in schools. However, if the LEA does, then they must comply with Title 68. And that's the healthcare rules about installing defibrillators. They have to be installed by a licensed physician. They have to be monitored, and the physician even has to determine, where they're placed. It does include that there's no liability for use if all requirements of Title 68 have been met. So we're involved for installing them. It's been changed a few times. What has happened is, I think after the law was first administered or implemented, people were putting them in locked. If you lock it in the school office and there's basketball practice on a Saturday and the office is closed, it doesn't do a whole lot of good to the people who need it. So the law is just clear that we encourage you to have them. It's a financial issue. If you have them, you have to have them in places where they can be used. If it's in a gym or a hall or places where, near the outdoor stadium during the football game. So I won't belabor that point. There is a law on CPR. It encourages, here again, any bill, you all know that when a bill is passed and it has a fiscal note, because every bill that is passed or is filed for the General Assembly, the Fiscal Review Committee actually has to put a cost to it. And what they do on the Fiscal Review Committee is they send bills to agencies. For example, if it's something about education, we get it. And we have to determine, and I usually hundreds of bills every session, I get to determine what the fiscal impact is of the bill. Now, if it's something that, I don't know, somebody is health related, I get help from the people who are experts in that area. If it's curriculum related, it's about reading curriculum, then we talk to reading curriculum experts. But these bills cost a lot of money, so it ends up being encouraged so it can pass. Basically, it encourages school districts to have employed or as a volunteer, at least one person certified as qualified to administer CPR, and LEAs are authorized to allocate up to 6 or more and a half hours a year in service days on CPR. Our state special schools, by the way, we have numerous people who are qualified. A couple years ago, we heard a lot on the news about air quality in schools. And are there any laws that require you to do testing on air quality? There's actually something in 49.2, 121. Each LEA is encouraged to conduct an inspection and evaluation program. Here again, you see the word encourage. It is not mandatory. So when you see a news story about the air quality in the school and the school districts get beaten up because they legally should be required to do air quality testing, actually it's not a mandate in Tennessee law. I think more school districts are doing this and testing for radon. All right. This is school health related, but not as directly as asthma inhalers, but hazing. This law on hazing has been on the books for years and years. Part of the attorney who handles the civil rights issues, a lot of times you're doing an investigation, maybe it's a Title VI or a Title IX issue, and it can be about hazing. And there for a few years, we've never heard of a hazing incident. And then it was weird, in the last couple of years, we've had several. Some serious hazing issues, locker room stop rooms. But technically, each LEA, according to this law, shall adopt a written policy. It's one of the required policies. Everybody has a policy. Everybody's probably put it in their student handbook with their other policies. But I don't think many schools are setting aside a time to discuss it at the beginning of every school year. So you may think about that. Now,
Is there a penalty for an LEA not setting a time?
there's no penalty it's like lots of statutes. You're supposed to comply with all these laws, and technically we're supposed to enforce them. And the only thing I know is we can withhold school approval. And every year, the Department of Education sends out a school certification document where every director has to certify that they're in compliance with all school laws and State Board of Education regulations. And you have to basically list the ones you're not in compliance with in your plan for getting into compliance as soon as possible. The problem here is people don't even know about this requirement anymore. It's been on the books for so long, and you know, we're charged with making school districts aware of these things, but there's so much out there, just kind of. But I think that because of all the talk about bullying and harassment, it's getting more attention now, and some more people are kind of rolling up that into one policy. Speaking of bullying and harassment, we do have a very strong bullying law in Tennessee, and it's been tweaked every year for the last 2 or 3 years. It requires school districts, all school districts, to have bullying policies. It defines the term. I'm not crazy about the definition of bullying in the law. I think it's very broad. And it's problematic because now school districts, starting August 1 this year, they have to report annually all their bullying incidences, how they've handled them, and the types of complaints that they've received. And we have a form. We've been sending out notices about it. We sent out a reminder recently in the director's update with a form. School districts also have to file a Title VI report and a Title IX report with our Civil Rights Office every year. The bullying is so, because you can have run-of-the-mill bullying. I'm bullying you because you're a Titans fan and I'm not. Or you can have bullying that's actually based on race or gender or disability, and that becomes a civil rights issue. Because some of them can overlap so much, we decided to combine the four. And it's all in one. And what we found at the department through years and years is we ask for the same information over and over again, different divisions. And so we're trying to stop that. I know it's annoying to school districts. So now it's this one report. It's only about 2 pages. And it clearly says Title IX, Title VI, and bullying. And there may be some overlap. You can tell the difference. But I think it's going to be helpful. I think it's going to be tough. The school districts have been asking a lot of questions about, well, when do we report it? What I suggest is having somebody responsible at every school, if you're a large district, who's responsible for bullying. And the principal is ultimately responsible for statute, so maybe they assign somebody to keep the documentation, who investigates the incidences, we put them on a spreadsheet, and somebody centrally that takes all the school information and puts it on one. And people have asked, well, and I had somebody say, well, we're only going to document the cases that we've investigated, that we've determined were actionable. I don't think that's what the statute means, because it even asks you to report pending cases that you haven't resolved yet. Well, if you haven't resolved it yet, then it may not end up being actionable. And so I think you have to, and I think it protects school districts. You need to show that you're tracking all of these issues and that you're handling them. The same way in our office, if we get a workplace harassment complaint, we log in and we investigate. Now, at the end of the day, we may determine through the investigation that the allegations were unfounded. But we log it in and we investigate and we come up with an investigation report. And we do have to send those in to the State Department of Human Resources as well, so I've already talked about the allergic reaction, the new legislation. Let's try to talk a little bit about 504. This is, a lot of people know a lot about IDEA. Because I think it's because IDEA is very specific and detailed. What you don't have in 504 is the detail. And sometimes I like to compare and contrast, where IDEA is a funding statute. Section 504 is a broad-based civil rights statute. I have had people say, well, we don't do 504, we don't get any money for that. And that always makes me laugh. I said, well, you don't get any money for complying with Title VI and Title IX, but you still have to follow it. So I think that's the main difference. I think 504, I think it passed, and it's a sister statute to ADA, so a lot of people don't. But I've had teachers, one principal, this is my favorite principal conversation about 504, called, and it was during the special ed, and I kind of, they overlap a little bit. Said, well, we have this child, they don't speak English in the home, so we 504 them. In the South, we actually use 504 as a verb, we 504 again. And I kept saying, well, what's the child's disability? And he would say, he doesn't speak English in the home. He doesn't speak English at all. I said, yes, but what's the child's disability? And I kept thinking, he's going to get this, going to get any minute. And I finally had to say, well, when I travel cancellation clause. You don't do an evaluation under IDEA and say, well, the child doesn't meet the eligibility criteria, and here's your lovely party exam, they filed a 4 point. It's not a consolation for a child who doesn't, is not deemed eligible for 504. And I used to get calls from school nutrition offices in schools that would say, the kid is making A's. This kid doesn't need a 504 plan. And what we know about 504 is it's not like IDEA where it's directly related to educational progress. Sometimes a child, it's about access to education. It's about leveling the playing field. So when you hear people say, well, we comply with 504, we treat every kid the same. That's not what 504 means. 504 is about leveling the playing field so all children have an equal access to education. I guess it's kind of like anybody who plays golf, it's the whole handicap system. It levels it a little bit so maybe Tiger Woods can play with me, you know, and I don't think the handicap situation would make much difference in those cases. But like I said, although we do try to provide guidance and mediation on 504, the sole responsibility for enforcement is with the U.S. Department of Education's Office for Civil Rights. The Atlanta office serves Tennessee. Everybody has protections who has an IEP under 504. You really don't have to go to 504 because that law is really going to cover everything that's necessary. Where IDEA, the eligibility is based on a definition. You know, there are disability categories in IDEA, and then locally at the state level, through the State Board of Education, we develop eligibility criteria. So how do you meet the criteria for a learning disability? Well, you look at the eligibility criteria, and those are developed with groups of practitioners and experts in the area. Eligibility for 504 is not based on clinical categories. It's not like, well, I like mental retardation or autism. It's based on the services that you require. And did you know there's a child fine provision within IDEA? Everybody knows that, child fine. The same thing is there for 504. It's not spelled out as clearly, but it is required. And 504 applies to any entity that receives funding under the federal law. You go through the definition of disability. And this is where I had to talk to the principal about what's the child's disability. A physical or mental impairment which substantially limits one or more major life activities. The student has a record of such an impairment or is regarded as having such an impairment. Now, have a record. Now, what would be an example of having a record of an impairment?
A health record.
Right. Or think about it this way. I did hear of some school districts that were struggling because they had children who were getting A's and B's, maybe all A's most of the time, and then when it was about time to take the ACT, they would all of a sudden need extra time on exams and they'd want a 504 plan. Maybe because the kid's getting B's because of their ADHD or something, but I think those are situations where you have to look at, there doesn't seem to be a substantial limitation of a major life activity. So, that was, and I think that was, a lot of times parents don't want their child to be stigmatized by having an IEP, being labeled as special ed, but they're not so uncomfortable with the 504 plan. So you do have to really determine, because if a child is eligible for IDEA, you really have to, you can't just give them a 504 plan because they prefer it. But you do have to have permission. I mean, you can't provide IDEA services if a parent specifically declines them. And that does happen sometimes. But when you're looking at substantial limitation, you look at the nature and the severity of the impairment, the duration or expected duration of the impairment, and the permanent or long-term impact resulting from the impairment. Bottom line is ADHD, ADD, those are controversial disabilities. And I think we can all agree that there are children who really have those and their education is affected by them. I see a lot of kids who have 504 plans for ADHD and ADHD. That falls under IDEA, under the other health impairment category. You know, I think if a kid has symptoms that are so severe that it's deemed to substantially limit a major life activity, I don't see how they can't be under IDEA. It's really strange. I think that's the one that I have the most trouble with determining when it's an IDEA situation and when it's a 504. But that is a matter for your local board attorney and your healthcare experts. Some examples of students who may not be eligible under IDEA specifically, but who may be, and that's why I said ADD or ADHD. You have a lot of kids who are deemed not eligible under IDEA. I don't see how you make them eligible under 504 without them rising to the level of being eligible for IDEA. Cystic fibrosis, spina bifida, mild cerebral palsy, LD with a discrepancy is not severe. Sickle cell childhood cancer. You can have disabilities that aren't permanent. You can have a child who breaks their leg, and it's a temporary disability. And you might need to provide some services just until that leg heals. I think people misunderstand that a 504 plan has to be something very complicated. And there also is that controversy. I know a lot of lawyers will say, let's don't call it a 504 plan, let's call it a healthcare plan. You cannot not call it a 504 plan and think that you get out from under the requirements of 504. If that child is eligible for services under 504, even though you don't ever speak the phrase 504 plan, they can still sue you if you don't provide service. Now, what the ultimate goal is, I don't care what you call it as long as they get the services, but what you have to also be mindful of is 504 has requirements other than just writing a plan and implementing it. You have to give certain notifications to parents of their rights under 504. So if you're not doing that, you're still in violation of 504, even if you provided a health care plan, and it says everything that your 504 plan can say. And that's one thing that OCR has been really talking about in the last few years, is trying to crack down on school districts who are not acknowledging that some children are entitled to a 504 plan and services under that law and the protections provided under that law. And recently we had, we have 136 school districts, and well over 100, a complaint was filed against all of them saying they didn't have proper 504 plans. And the former attorney in my office, Leslie Farmer, was trying to work with OCR in Atlanta to try to come up with a way to resolve it statewide with all the school districts. What the problem was is they didn't have proper due process procedures in their policy for parents who had a disagreement about their child's 504 plan. Under that law, you can request a due process hearing, similar to what you can request under IDEA. And a lot of school districts will actually use the ALJs from the Secretary of State's office who handle IDEA due process hearings. Now they pay for them separately, with local funding, but they're obviously attorneys who are judges who are very well versed in those laws and they feel comfortable. Some of them use just other random attorneys within the communities. But even though school districts know about that obligation, it wasn't in their policy. They didn't have specific procedures set up, so parents knew who to call and how they call the complaint and what would happen next with the procedure for getting a hearing. So Leslie's office developed a policy, and the Tennessee School Boards Association drafts sample policies, and they kind of put it into their sample policy manual, and most school districts just simply adopted that. And the 504 complaint required school districts to put a link on their website so that parents had access to it. So, and they had to get training. So an attorney from the Office for Civil Rights in Atlanta came recently and did at the special ed conference and did a 504 session. So if you had someone from your system attend that and sign in, then your system, if the complaint got checked off as completed on the training, if you adopted the new TSBA sample policy, you have a policy in place, you had to put a link. I think we're wrapping it up now with OCR, and I think all school districts are going to be deemed in compliance with that. But the point is, they're really looking to make sure that school districts are complying with the law and not just saying, we're going to give you a health care plan. And that is all the time I have. I apologize I didn't get through all the slides. Does anybody have any questions? Not about physical health? I'll give you a copy of this, and if you have school districts, if you want me to come, or Bill Wilson, who does IDEA, to come in and speak, that's what we do as part of our job. It doesn't cost the system anything, and I do training on, my most popular training probably educator ethics. We cover everything from social media, what to do and not to do on Facebook and Twitter, to interactions between students and teachers, which is a very hot topic now, and a lot of school districts are drafting policies on those things. Fourth Amendment, student searches, you know, all the student rights type stuff, but we can craft special trainings. So I appreciate you being here, and I can't believe that anybody, y'all didn't want to go to the garden. When I found out I was presenting opposite her, it was disappointing.